From Goldwater to Zivotofsky, the political question doctrine in the D.C. Circuit. A program planned and developed by the Historical Society of the District of Columbia Circuit, March 7, 2018. Stephen I. Vladeck, professor at the University of Texas of Law, sets the stage, followed by a reenactment of the argument before the U.S. Court of Appeals for the District of Columbia Circuit. The reenactment is led off by Catherine M.A. Carroll, arguing for the appellants James Carter et al. Arguing for the appellees Barry Goldwater et al. Is Harold Hongju Koh, with judges Harry T. Edwards and Stephen F. Williams for the D.C. Circuit presiding. The program concludes with a panel discussion with Mr. Vladeck, Ms. Carroll, Mr. Koh, and Beth Brinkmann, former Deputy Assistant Attorney General in charge of appeals for the U.S. Department of Justice. Moderated by Paul M. Smith, Vice President, Litigation and Strategy with the Campaign Legal Center. And now, setting the stage with Stephen I. Vladeck.
On Tuesday, November 13, 1979, the U.S. Court of Appeals for the D.C. Circuit, sitting on banc, heard oral argument in Goldwater v. Carter, a lawsuit challenging President Carter's unilateral termination of the United States 1954 Mutual Defense Treaty with the Republic of China, or Taiwan. In a few minutes, we will all be treated to a reenactment of that argument before Judges Edwards and Williams, but to help set the stage, I'd like to spend a few minutes summarizing both the factual and legal background to the case. So the facts. On December 23rd, 1978, President Carter gave notice that he was unilaterally terminating the 1954 Mutual Defense Treaty between the United States and Taiwan, one of a series of measures the Carter administration undertook in late 1978 to minimize or altogether cut off the U.S. relationship with Taiwan as precursors to the formal establishment of diplomatic relations with the People's Republic of China 9 days later. Immediately thereafter, 9 senators, a former senator, and 15 members of the House, led by Arizona Senator Barry Goldwater, filed suit in the D.C. Federal District Court, seeking declaratory and injunctive relief to the effect that the president had acted unconstitutionally in terminating the treaty without congressional, or at the very least, Senate consent. On October 17, 1979, D.C. Federal District Judge Oliver Gash, who had been named to the federal bench by President Johnson in 1965, sided with the plaintiffs. In particular, his opinion included 3 distinct holdings. First, that members of Congress had Article III standing, quote, to seek a judicial declaration with respect to the constitutionality of the president's unilateral termination of the 1954 treaty, unquote. Second, that the dispute did not present a non-justiciable political question. And third, on the merits, that President Carter lacked the authority unilaterally to terminate the 1954 treaty because the Constitution clearly contemplated a shared role for Congress through the Senate and the President in the formation and reformation of treaties. With regard to the second holding, Judge Gash rejected the government's argument that inter-branch disputes over the conduct of U.S. foreign relations present non-justiciable political questions, and to put that analysis into context and to help set the stage for the argument you're about to hear, I think it might help to say a few words about the state of the political question doctrine circa 1979. So at its core, the political question doctrine provides that there is a small but meaningful class of legal disputes that are beyond the ability of the federal courts to resolve. The doctrine can be traced all the way back to Chief Justice Marshall's 1803 opinion in Marbury versus Madison, still rightly decided, Justice Kennedy, in which, on way to cementing the power of judicial review and striking down part of Section 13 of the Judiciary Act, he explained why that case did not present a political question. That is why William Marbury had a legal right to seek relief against Secretary of State Madison for refusing to deliver his commission. As Professor Lewis Henkin would write in 1976, that there are political questions, issues to be resolved, and decisions to be made by the political branches of government and not by the courts is axiomatic in a system of constitutional government built on the separation of powers. The harder part, of course, is drawing the line between those disputes that present political questions and those that don't. So, for example, the Supreme Court in 1849 held that a dispute between 2 factions, both claiming to be the duly elected government of Rhode Island, it's a good one, was non-justiciable and was instead up to Congress to resolve, even though the actual case in which the matter arose was a simple action for trespass, and even though the Constitution arguably also carved out a role for the president in such cases. To this day, that decision, Luther versus Borden, remains good law and forecloses litigation over the scope of Article 4's guarantee to each state of a Republican form of government. It's why, among other things, litigation over gerrymandering today tends to end up focusing on equal protection and/or First Amendment claims. But perhaps the Supreme Court's most well-known discussion of the political question doctrine came in 1962, when in Baker versus Carr, the court held that disputes over redistricting were not categorically non-justiciable, overruling a 16-year-old plurality opinion to the contrary by Justice Frankfurter. In the process, Justice Brennan's majority opinion identified 6 categories of disputes that have presented and going forward would present political questions. And of course, the 2 categories that tend to come up the most often include cases in which the text of the Constitution commits final resolution of the dispute to some other actor in the federal system, what's often shorthanded as a textually demonstrable commitment, and cases in which the dispute lacks judicially manageable standards to govern its resolution. Both in the 17 years between Baker and Goldwater and since, the Supreme Court has generally been reluctant to hold that a dispute raises a political question. As we'll discuss after the argument, this culminated most recently in the Zivotofsky case, in which the Supreme Court held that a dispute between Congress and the president over whether Jerusalem should be identified on passports and in other official documents as being part of Israel did not present a political question. But the lower courts have not been quite as skeptical. Thus, for example, dozens of lawsuits seeking to litigate the lawfulness of the Vietnam War were turned away by lower courts on the basis of the political question doctrine, with some of those rulings and rulings in other cases referring in broad and sweeping terms to the inappropriateness of judicial interference in foreign affairs disputes. In his October 1979 decision, the one that is about to be reappealed, Judge Gash distinguished these cases, holding that the Constitution was silent on the question of treaty termination, such that there was no textually demonstrable commitment of the matter to the political branches, and that there were perfectly adequate judicial standards to settle the constitutional question, i.e., whether the Constitution required 2/3 of the Senate, or in the alternative, a majority of both houses of Congress, to consent before the power to terminate a treaty could be exercised. As Judge Gash concluded, the court is confronted with a clash of authority between the 2 political branches in a posture suitable for judicial resolution, unquote. Now, as I mentioned a few moments ago, Judge Gash resolved that clash in favor of the plaintiffs. The government immediately appealed, and the case was set for an initial en banc hearing on November 13th, just 26 days after Judge Gash's ruling. So at this point, I'd like to introduce the participants in the reenactment. Representing the appellants, President Carter et al., is Catherine M.A. Carroll, who is the partner in charge of the Washington, D.C. office of Wilmer Hale, LLP. I hope Catherine and the rest of the participants will forgive me for eschewing longer recitations of their dazzling resumes, but don't take my word for it, go look them up. Representing the appellees, Senator Goldwater et al. Is Harold Hongju Koh, the Sterling Professor at Yale Law School and former legal advisor to the State Department. And of course, hearing today's argument are the Honorable Harry T. Edwards and the Honorable Stephen F. Williams. So please join me in welcoming the reenactors. And with that, we will hear argument this afternoon in number 79-2246, Goldwater versus Carter.
Good afternoon. May it please the court. Catherine Carroll on behalf of the appellants, and with the court's permission, I'd like to reserve 2 minutes for rebuttal. Your Honors, the district court erred in reaching the merits in this case because the method by which a treaty is to be terminated, and in particular whether, when, and how the Congress must be consulted, is a non-justiciable political question that should be left for resolution to the normal back and forth of the political process. Now, the President's termination of the Mutual Defense Treaty in this case was part and parcel of his recognition of the People's Republic of China government and of his negotiations to normalize relations with that government. The plaintiff's suit here asks the court to hold that the President should have conducted those foreign relations differently, to declare that the President's words and actions on the foreign stage are a nullity, and to reinstate a military alliance with a government that this country no longer recognizes. the courts lack authority to mediate that political dispute, principally for three major reasons stemming from the Baker v. Carr factors. First, with respect to the question of textual commitment, in this case, the Constitution gives no answer to the question of what the extent and form of congressional participation in a termination should be. And as in the Walter Nixon case, by failing to specify any limitation on the manner of termination, the Constitution thus leaves the question to the political branches and gives the judiciary no metric by which to judge the issue. And the historical practice bears this out. As set forth in the briefing, terminations of treaties over the history of the country reflects that in each instance—
I thought that in Nixon, at least once you came to certain conclusions on what trial and solely meant, it was a textual commitment. I mean, a formal textual commitment to the, depending on which part, for the trial, the Senate. Well, we don't have anything like that here, do we?
Well, I think the textual commitment in Nixon was found in the fact that the word try, in particular, was broad enough and capacious enough to allow any number of meanings, and thus did not limit the Senate's authority to prescribe the methods. That stands in contrast to, say, the issue in the Adam Clayton Powell case, where there was a question of textual commitment with respect to the House's authority to determine the qualifications for seating a member of Congress. And in that case, by contrast, because the Constitution precisely and explicitly enumerated the qualifications, the court concluded that one could not infer that there was a textual commitment of authority to the House. So as between those two contrasting cases, this case lines up much more directly with Nixon in light of the fact that there is no precise statement of standards. And it's because there's no precise statement of standards that also indicates that there's no judicially discoverable or manageable standard for a court to apply.
Let me follow up with that, if I can. I don't think this is a case, I don't think you're saying this, I don't think it's a case in which you're suggesting that the withdrawal of treaties is committed to the authority of the president. And most of the cases that you cite, that are cited in your brief, do not involve situations in which the executive and the legislative branches have advanced competing claims for authority, and the courts routinely decide those cases. So it seems to me your best argument is there are no judicially discoverable or manageable standards. But when you look at the brief, you're only citing two cases, Luther versus Borden, and that has been alluded to, and Coleman versus Miller, whether Kansas can ratify an amendment to the Constitution. Neither one of those cases involves situations in which the two political branches were contesting or raising competing claims of authority, and they seem quite different here. Do you have any other authority?
I think that the Nixon case, as I've already referred to, and I think also the decisions of this court and the other courts of appeals in the cases that have been mentioned regarding attempts to ask the courts to police the executive's conduct of military operations in Indochina. Those precisely were claims, Your Honor, where the assertion was that the executive's conduct was invalid precisely because it had not allowed for adequate congressional participation. So that similarly pitted a contest between what was the requirement for the extent and form of congressional authorization before the president would have the authority to conduct, whether it was the mining of the North Vietnamese harbors or the bombing of Cambodia and so on. And we think that's the same kind of posture that exists here. And with respect to the lack of manageable standards, the district court's opinion provides perhaps the best evidence of why there's an absence of manageable standards here. And I think that's true for at least two reasons. Number one, considering what the district court said about historical practice, where the court agreed and acknowledged that there had been some situations where the president had terminated unilaterally. And the district court said, well, those were situations where, the treaty might not have been as important, or there was not a faithful ally at play, or there may have been a breach or some event that superseded the treaty or rendered it needless in some way, as if to suggest that in those cases, there wasn't really a reason why it would be a good idea or necessary to have congressional participation. That distinction comes from nothing in the Constitution. It comes from a fundamental policy decision about how foreign affairs should be conducted and when it's appropriate or helpful to have congressional participation. Secondly, the district court concluded or perhaps stopped short of concluding what the actual form and extent of congressional participation should be. Did it have to be a 2/3 vote of the Senate? Did it have to be a majority of both houses? The court declined to resolve that and said either would go, but didn't explain why other alternatives wouldn't have proved equally sufficient. And again, as in the Coleman case that Your Honor mentioned, that is a perfect example of why courts are not appropriately inserting themselves into these kinds of questions where the Constitution provides no basis to make a decision, but instead...
But there are cases. Why shouldn't we treat this case, and especially where you have competing claims between the two political branches, why don't we treat this case like the Appointments Clause cases, where there's no clear answer, and yet, in a number of those cases, and yet the courts have not hesitated to weigh in? Kennedy v. Sampson, the pocket veto, U.S. v. AT&T, the subpoena of wiretaps, and Zivotofsky.
Conceitedly, Your Honor, there is a distinction between deciding a constitutional question or interpreting a statute, as was the case in Zivotofsky, and the underlying policy judgment.
Don't we have a statute here? We have the Taiwan Relations Act, and we have its explicit provision continuing the treaty with Taiwan until it has been terminated, and clearly, at least arguably, the terms under which the president purported to terminate were not legal grounds, were not consistent with that statute.
Well,
why isn't this just a replay of Zivotofsky?
The claim here is not a claim that the president's conduct violated the statute. The claim is that, as a matter of constitutional law, the president was not authorized to do this without congressional authorization, and that makes this very different from Zivotofsky. I acknowledge it doesn't make it different from some of the other cases that Judge Edwards mentioned, where the court went ahead to decide a constitutional question with respect to the separation of powers. But with respect, that distinction is illusory in the context of this case, because there is no way to decide that constitutional question without effectively deciding how the president should have carried out the conduct of foreign relations. So to give an example, suppose there were a situation...
The only thing that would have to be decided in terms of how he should conduct foreign relations is the point that for derecognition, he would have to get Senate or congressional approval.
The same could have been...
That's not... And if we plunge into this, and if we say that indeed that is required, future presidents will bear that in mind and will consult as needed before they end a treaty.
Well, two responses to that, Your Honor. First, I think the historical record demonstrates that in light of Congress's many tools to participate in the political process and its many sources of bargaining power, the president has historically, when deemed appropriate to do so, consulted with the Congress and engaged in the back and forth accommodation and compromise that our political system envisions. So the decision in this case is unlikely to alter how those questions have been approached historically. But with respect to why isn't this...
Why wouldn't it? I mean, if the president has to get approval, he's going to bear that in mind in negotiating with the PRC and obviously equivalent negotiations around the world.
But that illustrates exactly why the constitutional question here cannot be disentangled from the underlying policy determination of how should the president go about conducting negotiations? How should the president go about implementing and executing an act of recognition of a foreign government?
You're mixing up the policy question of recognition of China and termination of Taiwan relationship and so forth with who participates in that policy determination.
Those are distinct questions, Your Honor. And in many cases, a court can decide the allocation of power without stating a view or a judgment on the underlying policy question. That is not the case here. Perhaps the best illustration of that comes in the remedy that the district court ordered here. What the district court ordered, the judgment that is under review, Your Honor, is a declaration that the president's communications to a foreign government are null and void and without effect, and enjoining the Secretary of State from taking any action implementing the president's policy judgment to recognize the PRC and to normalize relations with them. Deciding the constitutional question.
Those remedies are not the only remedies one can imagine.
But that was the remedy that the plaintiff sought and that the district court ordered and that is under review here, and it clearly intrudes into the president's conduct of foreign relations in a way that cannot be separated from the constitutional question. Suppose you have a situation where—
It could be separated by just saying that until something else has happened, the treaty with Taiwan persists. To be exact, the treaty with the Republic of China persists. Right? That could be the relief.
That is effectively the relief, rather than a single-voiced determination by the president that the treaty has been terminated. We now have competing statements by the executive and by the district court as to whether the treaty has been terminated or not.
Then they can proceed to negotiate and work out a—
Well, taking the issue to the court interrupts that process, however, because there's not a negotiation between the president and the court as to how the termination should happen. If you have a situation, say, where the president believes that the circumstances are such that there's a significant exigency that requires immediate action, for a court to say, no, you have to stop and slow down and make sure that you get Congress's approval first, that is fundamentally a determination that foreign policy has to be conducted one way and not another. I see that I'm past my red light. I don't know if you can see my red light, Your Honors.
We can't see it.
But if,
Oh, yeah, no, I can see it.
if I may, unless the court has further questions, if I reserve the balance of my time?
Yes.
Fine.
Yes, sure. Where is the light? You may proceed, counsel.
May it please the court. This case presents a pure question of law. If the government's attorney is correct, this court would be obliged to stand by mutely while the president, with a single tweet, withdrew us from the United Nations, NATO, the International Monetary Fund, the World Bank, the World Trade Organization, and NAFTA. This cannot be the law. The two basic factors which have been correctly identified are that there is no textual commitment to a coordinate branch. It says who can make a treaty but does not commit to any branch the duty of unmaking a treaty. And secondly, the standards are manageable for the reasons that have been stated by Judge Edwards. The executive and legislature are advancing competing theories of how this can be done. And as in Youngstown, as in Myers, as in Marbury, as in Zivotofsky, which is a controlling case here, those are sufficient to hold that this case is justiciable. In fact, this case is on all fours with Zivotofsky in the sense that the question there is whether one branch has encroached on the separation of powers prerogatives of the other. In Zivotofsky, the claim was that the statute had encroached on the authority of the president to recognize. Here, the question is whether the president has encroached with his unilateral termination on the legislative prerogatives of Congress to participate in a decision to unmake a treaty.
What are the judicially discoverable and manageable standards to guide adjudication here? This looks a lot less appealing than Zivotofsky on that score.
Well, Judge, it's a hard job, but I think you're up to it. As Chief Justice Roberts said in Zivotofsky, it's a matter of looking at text, It's a matter of looking at structure. It's a matter of looking at historical practice.
Where does the text lead in defining the minimum necessary role for Congress? I mean, the district court offered two possibilities: 2/3 of the Senate, majority of both houses of Congress, and there's also, as your adversary suggests, there's the 1/3 plus 1 of the Senate, which a lot of logic supports that, because that would have been enough to negate a treaty. Why shouldn't it be enough to bring a treaty to an end? So that's surely a logical candidate.
If we were to argue the merits, I would argue both. But I think the simple point is that the treaty is the law of the land. And the question is whether the president can repeal the law of the land by himself. When a statute is the law of the land, it requires the president and Congress acting together to repeal the force of law. And that's what is the case here. There's an attempt to draw an analogy between appointing an official and firing an official, saying that appointing must be done with the advice and consent of the Senate, but the president can fire the subordinate alone. But it's quite different in a situation where the issue is whether you can control subordinates within your own branch from the broader question of who controls our engagement with the entire world order, and whether that decision can be taken by one person acting alone who is repealing the law of the land by his own action.
We know that as a practical matter, notwithstanding Congress's exclusive power to declare war, the president has unilateral power to get us into war. I mean, this is sort of lesser included against that, is it not? I mean, I'm talking not the constitutional language, but the political reality.
Well, the president is commander-in-chief, and that gives him a different kind of authority. This is also an area that's been regulated by statute, the War Powers Resolution. There is, in this area, the Case Act, which controls how commitments are made, which require consultation and notification to Congress. And Congress is clearly engaged. The issue of our relationships with foreign governments is something in which Congress has played a significant role. And the issue is a pure question of law. Is the president's actions alone legally sufficient? If it is, he can terminate by himself, and then he can terminate from every treaty to which we are currently a member, and that's
Can
not.
Congress pass a statute that says the president can never terminate a treaty unless it's been approved by 2/3 of the Senate, and the president vetoes the bill, Congress overrides it easily, and now it's the law? Does the president have a right to come in and challenge that and say, can't be?
He certainly can. If it is the law, then you're in a
Gonna win?
situation in which pardon?
Will he win? Should he win?
The only question from my perspective is it justiciable? I don't think that the competing claims of the two branches are going to be resolved by the two branches of government deciding on their own. This is something that calls for courts to make a decision and decide whether he has the legal authority. As Chief Justice Roberts said in Zivotofsky, this is what courts do. It's not an inter-branch exercise as in Nixon. It is an inter-branch exercise. And in the breaking of the tie, this is a red light, green light situation. You're not being asked to monitor a speed limit. You're being asked to determine whether the president's action alone is legally sufficient, or whether additional congressional action is also required.
An early question. You frame it as yes or no, president's action alone. Suppose we tentatively say alone is not enough. Then we have to say,
What?
With what else? And there are at least three possibilities in play, as far as I can see. And I don't offhand see judicially manageable standards for picking among them.
Well, Your Honor, in the course of making an international agreement, there are also three standards: sole executive agreement, congressional executive agreement by a majority of both houses, or a 2/3 process. The court could analogize from these three into the termination or withdrawal setting. It's an important question for the merits. Under Chief Justice Roberts' controlling reasoning in Zivotofsky, you look at the text, structure, and history, you will find that there are extraordinarily few examples where a treaty has been terminated without congressional participation. And you will also see that that historical record has not been supplemented since the actions here. The real question for the government's attorney is there any limiting principle, or is every single engagement, international engagement, made bilaterally or multilaterally terminable at will by one man acting alone? And that is a pure question of law, which only this court can decide. This is not like Nixon, where the Constitution gave the Senate the sole power to determine. And as you pointed out, that if, like Caligula, they appoint the horse to be a senator or an elephant in the zoo to do the delegation, even that might be non-justiciable. But as Judge Edwards has correctly pointed out, this is a garden variety battle between the branches over who has the authority and who decides. And the court is not free to duck the issue of deciding who decides. Only the court can do that.
I suggested to your opposing counsel that if we ruled against her position, that presidents and Congress, different groups in Congress, would work out accommodations so that, in fact, the U.S. would still end up speaking with one voice. But historically, we have, in matters of international relations, spoken with one voice, which happened to belong to the president, not, at least for many situations, not to Congress and the president. So, I mean, could judges reasonably count on this new regime working out satisfactorily?
I think it's your province.
Highly policy-oriented question.
No, I think it's a Marbury question. It's the province and duty of the court to say what the law is. If you say what the law is, that says what the Constitution requires. Both the president and the members of Congress are sworn to uphold the Constitution and laws of the United States. If you even put it in the form of a declaratory judgment and you made the clear rule, they would then know what the answer is. And they could bargain then around the correct rule as opposed to around a state of ambiguity, which is where a political question ruling would leave this case.
Does history matter? And again, I'm not sure whether this is on the merit side or on the justiciability side. Does history matter in our thinking? And if so, the president has done this in the past historically, and there have been no challenges to suggest it was impermissible. Why now?
Well, I accept part of what you've said, Your Honor. History does matter. Justice Frankfurter in the Steele seizure case said that actions by the president taken, or by one branch taken without or with the acquiescence of the other branch, are historical gloss on the meaning of the executive power. Where I think I disagree is on what the historical record would show. The briefing in this case has shown that, in fact, there are only 3 examples in which the president acted alone, and that it's not at all clear that those are the controlling examples. There are many, many more examples in which Congress and the president were both involved.
I was struck by the fact that the Senate confirmed the appointment of an ambassador to the PRC, presumably understanding exactly what was involved. So, I mean, perhaps, I mean, an answer which ought to be in our mind as to possible solutions, if we did reach the ultimate question, would be that Congress's voice can take at least that form, and that's sufficient, and here it threw it away.
Your Honor, the fact that the Senate might want Mr. Woodcock to be our ambassador to Beijing is not a statement that they don't also want to continue the Mutual Defense Treaty with Taiwan, which addresses a completely separate issue.
We're told that the premise of the relations with the PRC were termination of the relationship with Taiwan. Now, the parties disagree on that, I recognize, but it sounds to me something very hard for judges to decide what the exact bargaining status is between us and the PRC.
Judge Williams, a number of presidents to the present day have discussed the possibility of maintaining relationships with both the Beijing government and the government in Taipei. That is a possible policy outcome. That's a separate question from whether the president alone has sufficient authority, legally sufficient authority, to terminate a treaty that is the law of the land. And on that, I think the legal question that's before you requires that Congress be involved. We think that Judge Gash has correctly put the point by saying that what is required at a minimum is either 2/3 of the Senate's participation or a majority of both the House and the Senate. And for
That's not a resolution. I mean, one reads that opinion and is immediately, as co-counsel would suggest, is immediately pushed to the conclusion that there are no manageable standards here, and the district court couldn't come up with one, and kind of threw up his hands and said, well, you know, you could do one thing or another. That's not what Zivotofsky is counseling.
Those are quite manageable standards, Judge. I think that it's a question. We have no idea whether President Carter, if he were actually to engage the political discussion that the Constitution requires him to have, couldn't get a majority of both houses for his proposed action, or even 2/3 of the Senate. He just hasn't tried. And the Constitution obliges him to try. That's what it means to have a power shared, as Judge Gash said in his opinion below. I think Judge Gash put it well. Identifying the correct allocation of constitutional power among the political branches falls uniquely within the judicial function. It is your province and duty to say what the law is. And as Chief Justice Roberts said in Zivotofsky, this is what courts do. It may not be easy, but I'm sure you will do it very well.
Thank you.
Thank you.
If I could make just a couple of points, Your Honor. With respect to Marbury's maxim that it is the law, that is the duty of the court to say what the law is, that's of course true, but the same could have been said to dispose differently of the Walter Nixon case, of the Indochina military operations cases. That maxim alone simply doesn't answer the question. To look at Zivotofsky, and Judge Edwards, I think this resolves your hypothetical statute as well. The critical distinction that Chief Justice Roberts drew in Zivotofsky was that in that case, there was a statute to be applied and evaluated. The court did not, as he put it, have to supplant its own judgment for a judgment of one of the political branches. It was merely being asked to apply a statute, not to do what the district court here did, was to determine whether, in a particular case, a unilateral termination might or might not be okay, depending on how important it was, and might or might not be required to conform to a 2/3 vote or a majority vote, and so on.
What you've said there raises a question that I've had for a long time, and that is, when the basis of finding that an issue is a political question is textual commitment to a branch, which is the way I read Nixon, for example, right. Is there any real difference between applying the political question doctrine and simply deciding on the merits that that branch wins?
It sometimes doesn't look that way. I think the Powell decision might be a really good example of that, where the court appears to consider the question presented, that is, does the House have authority to do what's being challenged, in order to determine whether it's been committed to the House to decide. But I think it does make a difference in terms of what is the proper role of the court in mediating disputes that have historically and by design been committed to the back and forth of the political process. Your Honor, history does matter here, and what the history here shows is that the political process has worked. Congress has tools to participate in these discussions. Those discussions have gone on over and over again. They happened here not only with regard to the confirmation of the ambassador, but also with regard to appropriations for an embassy and so on. the political process works, and by having a court inject itself to be referee between the political branches, it takes away that latitude to accommodate and compromise back and forth.
What would be the answer to my hypothetical if Congress passed the law and overrode the veto, and the president is now standing there saying they can't do this, but what?
I think that would be analyzed the same way as Zivotofsky. The question there was, does a particular statute impinge on the president's authority? It wasn't a situation where the court was being called on to devise its own standard or rule to govern the situation, as we think is what is happening here, where the court is being asked to decide what are the situations when Congress's participation would be a good idea, and how should their participation be accomplished.
On the merits, even though we're not deciding the merits, on the merits of my hypothetical, what would the president's claim be?
Of course, the statute can't interfere with the president's conduct of his
But does
power
that
in
mean
sense.
the president could successfully argue that I alone can make the decision?
The termination decision?
Or that a statute in this form, yes, that I alone can make the termination decision?
The position of the president in this case is that a unilateral termination is not precluded by the Constitution.
All right, so in my hypothetical, you would say it would be the same argument being advanced, yeah? Okay.
Correct.
Yes.
Thank you.
Thank you, counsels.
Thank you.
We appreciate it. The case is submitted.
So before segueing to the panel discussion, I thought I would just fill in what happens next in the story. 17 days after the oral argument, the D.C. Circuit hands down its decision on Friday, November 30th, 1979. In a per curiam opinion, the court reached the merits after noting that 2 of the 7 participating judges would have reversed Judge Gash for lack of standing, and that, quote, there are no votes to reverse founded on the political question doctrine, unquote. At this point, you might be wondering what this case has to do with the political question doctrine. It's coming. And on the merits, the court reversed Judge Gash, relying heavily on the presence in the 1954 treaty of an express termination provision and the absence in the ratification debates for the treaty of any effort on the Senate's part to reserve a role for itself in utilizing that provision. On those terms, 4 of the 5 judges to reach the merits held President Carter's action to be constitutional, with only Judge McKinnon dissenting. 2 weeks later, the Supreme Court gave the case a rather unusual denouement, granting certiorari, vacating the en banc Court of Appeal decision, and remanding with instructions to the district court to dismiss. And that was it. You may be familiar with the term GVR. This is my only experience with a GVD. Although the court's order provided no further elaboration, several of the justices wrote separately. 2 justices, White and Blackmun, would have set the case for plenary briefing and argument. Justice Brennan would have simply affirmed the Court of Appeals ruling. And the other 6 justices all joined the result in some respect. Justice Powell argued that the dispute was not ripe because Congress had not taken any specific and direct action to confront the president, threads of what we heard in the argument. Justice Marshall concurred in the result with no further statement. I want that job. And writing for himself, Chief Justice Berger and Justices Stewart and Stevens, then Justice Rehnquist, wrote that he agreed with the disposition because he thought the dispute did indeed present a non-justiciable political question. The only 4 of the 17 judges to hear the case who so concluded. Then Justice Rehnquist's opinion focused on the idea that there was a lack of judicially manageable standards because no one could convince him exactly what the question he was supposed to answer was. Thus ended Goldwater versus Carter, with a practical, if not formal, victory for President Carter, since there was no contrary legal decision to disturb his termination of the treaty. But not the continuing uncertainty over either the specific question it presented or the more general appropriateness or lack thereof of applying the political question doctrine broadly in foreign relations cases. And in the 38 years since, the Supreme Court has only recognized 2 political questions: disputes over the procedures the Senate uses to remove and impeach federal judge, that's the Walter Nixon case, and constitutional challenges to partisan gerrymandering. And as importantly, the justices in Zivotofsky, as you've heard, notably reversed the D.C. Circuit, with the exception of a particular judge who may have concurred in the judgment, with Chief Justice Roberts writing for an 8-to-1 court that just because the dispute implicated foreign relations, that didn't mean it was non-justiciable. On the contrary, where federal courts are presented with a square conflict between Congress and the president over the allocation of foreign relations power, they can and should resolve it. Zivotofsky notwithstanding, the lower courts, including the D.C. Circuit, have shown somewhat more fealty to the political question doctrine in foreign relations cases in those ensuing 38 years. And I think that's a fitting point on which to segue to our panel discussion, and for me to introduce the moderator, Paul Smith. Paul is currently the Vice President for Litigation and Strategy at the Campaign Legal Center, and among many, many other things, has argued in the Supreme Court in 3 of the court's 4 most recent political question cases. How you miss Zivotofsky, I'll never know. In Veith, Lulock versus Perry, and just this past October in Gill versus Whitford. So I think, panelists, we should head up that way.
So this is obviously a great panel. You've seen the remarkable expertise displayed by 3 of the 4 panelists who have already been participants and in many ways played the harder roles already. The 4th on the far end is Beth Brinkmann, my old friend, who is a great, distinguished appellate lawyer here in town. Was in the civil division before that in the Solicitor General's office, and is now practicing at Covington and Burling. Like me, she has some experience in this area with the decision that she argued when she was in the civil division, the El Shifa case. One of the cases I think we're going to talk about as we talk about where we are on this doctrine, these war on terrorism cases that have been percolating up to this court and to the Fourth Circuit as well. I guess I thought maybe since Steve, you sort of brought us a little bit up to where we are, it might be nice to talk about the Court of Appeals cases that have really been where the action is, other than Zivotofsky in recent times. And Beth, maybe you could start us off on that. Talk about some of those cases, and maybe talk about the special role that the D.C. Circuit has played in this area, not just in Goldwater, but in much more recent times.
I'd be happy to, and thank you for the invitation. It's very rewarding and interesting to hear the reenactment and to also consider the ongoing aspects of the political question doctrine. The D.C. Circuit plays a very unique role for a couple reasons. The most obvious is the venue here. If you want to sue the president or the secretary of state, you're going to come to D.C. And indeed, El Shifa, the case that Paul talked about that I argued here in banc, involved a defamation, alien tort suit, many, many claims against the president, against members of the White House for the bombing of what had been believed to be a chemical factory in the Sudan involving weapons of mass destruction. It was a retaliatory strike after the strike in Africa. And that was really coming to the court very much at the same time as the Zivotofsky case. So there was an interaction between those cases as they were going through the panels and both seeking in banc. So that venue was just one of the natural reasons that the D.C. Circuit gets that. Another aspect, though, that I think is really important of the role that the D.C. Circuit plays in this area is the other aspects of its docket that brings to the court so much familiarity with foreign affairs and national security. These are cases like the habeas cases involving Guantanamo, or the cases before the court about foreign terrorist organizations under EDPA and deciding issues under that. There is a docket here that gives the judges an experience to know that everything that involves foreign affairs is not a political question, and yet there are some things that do cross that line. I think that really is a unique aspect of the D.C. Circuit. Another point, I think the final point I would just make as a kind of institutional role is the fact that the D.C. Circuit then becomes the final word on many of those cases because they don't go on to the Supreme Court. And just hearkening back to the interaction between El Shifa and Zivotofsky, the richness of the D.C. Circuit's in banc practice, and it's different from other circuits. Some barely ever go in banc. Not only does the D.C. Circuit go in banc, but they also don't hesitate to dissent from denials of in banc. So that to me is a really unique role of the D.C. Circuit here in those cases. More specifically in the recent cases having to do with the war on terror and the bombings and those different kinds of alien tort statute claims that come here, they do serve up those But I think in the cases that raise constitutional issues like Guantanamo and habeas, they really understand the constitutional mandate to review.
Right. So maybe we should talk a little bit about some other cases. El Shifa was the attack on the factory in Sudan. The Bin Ali Jabr case was a particular drone strike in Yemen that, while I think it got some of the bad guys, got some of the good guys too. And both of those were heard by this court and held to be political questions, right? I mean, I'm a gerrymandering guy, so anything foreign affairs is not my field. And there's also a case in the Fourth Circuit, the long-running Al-Shamari case, which involves a challenge to contractors who allegedly engaged in torture in Abu Ghraib in Afghanistan. Are there other cases like that that are sort of just to complete the picture?
I mean, I tend to think of the sort of rich areas of development in the political question doctrine these days as really being in two very discrete axes, right? One is the gerrymandering cases, which, Paul, as you know, can come
About to
from—
go away altogether, right?
And they can come from anywhere.
And they don't arise from the D.C., and they're often three-judge courts.
That's right.
And then, for all the reasons Beth laid out, I mean, I think the reason why you have some of these non-DC Circuit foreign relations cases is in the unique context of tort suits against private military contractors, where there are compelling personal jurisdiction and venue reasons,
Right.
why the cases might not be here.
The Al-Shamari case in Fourth Circuit, right? Yeah.
Exactly. And so I think, those are this is not to say that you couldn't tomorrow have a new kind of dispute that raises a political question, but those are, I think, the two richest, most fertile areas of doctrine these days.
Well,
one other thing I just want to mention about El Shifa, too, is there were 4 judges who ruled for the government, but on different grounds also. And I think that's part of this. They tee up these issues, not just in banc, but also on alternative grounds. Judge Kavanaugh wrote this opinion rejecting 4 or 5 attempts to create a cause of action, for example.
And the case that Beth argued in the D.C. Circuit wasn't even the only circuit-level decision in El Shifa, right? The Federal Circuit in 2004 held that it was a political question whether, in fact, the Sudanese pharmaceutical plant was an enemy, such that it was subject to the enemy property doctrine under takings law.
It involved the Tucker Act, too.
Where the law seems to be moving in this area is attacks on the government's decisions about particular military actions, at least in this court, have been held to be political questions, whereas the contractor case in the Fourth Circuit, it seems to be heading in a different direction. Let me just turn it over to Harold for a minute and say, do you see this, even though the doctrine has not been utilized a great deal in recent years, as an emerging area where foreign affairs of the kind that we're talking about here, particular military tactical decisions and stuff, are going to continue to be protected by the political question doctrine?
I think Zivotofsky, which is a foreign relations case, has very substantially narrowed the political question doctrine to prongs 1 and 2 of the Baker 6-factor test. It's essentially now a textual doctrine that turns on textual commitment and judicially manageable standards, and I think that's a good thing.
You could argue that it's always been that, basically, that the other 4 standards are all sort of encompassed in those 2. At least I've certainly.
I think the migration from Baker, which is a electoral political thicket case, to foreign affairs was unwarranted. And take a look in, for example, the 9/11 cases about detention. Hamdan, Hamdi, Padilla, Rasul, Boumediene. All of them were decided on the merits, and they had a very substantial effect, I think, in limiting abuses and sending a message to the executive branch that they had to answer to somebody else. I think when President Obama gave the speech at the National Defense University in 2013, he acknowledged the possibility that there could be judicial oversight after the fact of drone strikes. That was certainly something that they were considering. So I don't come away from this with the notion that there's some zone where the political question doctrine needs to be given very broad sway. At the end of the day, only the courts can decide the question of who decides. And if they don't, then the president can do all kinds of things, as I suggest in the argument, completely unchecked, and the courts have no role to play, when in fact it's just ambiguous on the face of the Constitution who actually has the power to make those decisions.
Right. There's a striking opinion concurring by Judge Brown in the Bin Ali Jabra case, talking about this complete lack of control that will exist if we allow things like drone strikes to be completely unreviewable. And Catherine, you want to describe that or talk about that?
Yeah, so Judge Brown, who wrote the opinion for the court, then
Concurred in her
separately
own
also
opinion, yes.
concurred in her own opinion to express concern that although the result reached by the panel decision was consistent and controlled really by the El Shifa en banc decision that Beth described, it did leave a situation where there was effectively no oversight or monitoring at all of what had become, in her view, an increasingly secretive, untransparent, and risky, dangerous practice enabled by a lot of the new technologies of warfare. And so she was sort of sounding the alarm there on that front and suggesting that maybe that meant, you know, if it's not possible to draw a distinction between a case like that and cases that had come before, maybe it was time for a wholesale revisiting of the doctrine. I mean, one thing that stands out to me in reading the El Shifa decision and thinking about your question on is it different in foreign affairs versus domestically is there's a passage where the majority in the en banc court is talking about the fact that when you're dealing with a grant of discretion involving foreign affairs or national security, that's just, we wouldn't review an exercise of that kind of discretion even if there were a statute conferring jurisdiction to review. Now, query how that stands post-Zivotofsky, but you read that and you think the bread and butter, or part of the bread and butter of this circuit in APA cases is there's been a grant of discretion and a statute allowing review, and to be sure it's deferential review, but the idea that the court would forbear from review just because there's been a grant of discretion is quite different from the sort of basic instinct of much of this court's docket on other kinds of matters of administrative law. So that stands out to me.
And even on similar matters through other vehicles. I mean, Harold referred to the habeas litigation.
Right.
You know, the government had argued very, very early on in the district court in the Hongju case in 2002 that those cases were political questions, and quickly abandoned that line of argument. And so I guess, you know, one of the things I've always been struck by is if it is within the constitutional authority and the practical competence of Article III judges to review classified national security information in the context of whether the government has met a sufficient quantum of evidence to justify the detention of a non-citizen captured on a foreign battlefield, which is the law of this circuit. Why is it so foreign, pun not really intended, right, to then turn around and say, did the government exceed, right, the limits that both domestic and international law place upon it, including statutes Congress has passed, in carrying out this drone strike? Right?
Clearly,
that's the disconnect I don't.
There's an instinct that at least some judges in this court have had that there's something different about affirmative military tactical decisions, attacks on plants or drones or whatever. And one question I have about it, I'll sort of throw this out to the group, which of the two branches that Harold identified of the doctrine is really operative in the El Shifa context? Is it really about a textual commitment, or is it about that there's no standards?
I think in El Shifa, the court really would had a very difficult time finding any kind of standard. That case was rooted in a purported cause of action for defamation and an alien tort statute, and the premise of those was that the strike had been a mistake. And so you really had to go to the validity of the reason that the president had for ordering that strike. And there was no statute, there was no standard, there was nothing of which to judge that. And I think that is very much comes forward also in Judge Kavanaugh's concurrence, talking about, I mean, basically he goes to such a standard to say, really, it's frivolous. And that's why he gets rid of the case and goes through each of those complicated causes of action and says, you know, this doesn't meet that standard. So I think that all of that reinforces, and actually in Judge Brown's opinion then, in her concurring opinion to her own, in the subsequent case, she really sees them as very distinct cases also. She talks about El Shifa as being this, I mean, for lack of it's not, to paraphrase, old-fashioned kind of case. You know, it's a missile strike every once in a while, as opposed to like a policy of ongoing drone remote actions. And that technological difference, I think, influences her about that balance of power.
Harold, you want to weigh
Well,
in?
I disagree with that, even though Beth was my lawyer.
We're supposed to disagree.
Jeff Kleinberg and I, when we worked at the State Department, we went to meetings in which the issues were, do these drone strikes meet legal standards, both of whether sufficient respect for the sovereignty of a foreign country and sufficient respect for the individual rights of the person whose life or liberty is being deprived. And the Office of Legal Counsel opinion written by David Barron, which was released, which talks about the due process rights, simply applies to Matthews versus Eldridge. The D.C. Circuit applies Matthews versus Eldridge every day. So when I hear, Judge Edwards said today, well, what about judicial standards? Every fall I have to explain to my students how the word equal protection of the laws means 2 or 3 tiers based on strict scrutiny, compelling state. Where do they come up with this? Or that, due process for the purpose of personal jurisdiction means minimum contacts equaling fair play and substantial justice, and the at-home test and all this other kind of stuff. Courts can develop standards to clarify what due process means.
And I said, it's worth noting, courts don't always have to do this themselves. So one of the things that's remarkable about the Al-Shamari case, this is the Fourth Circuit case, torture in Abu Ghraib. Judge Lee ruled after the 3rd remand from the Fourth Circuit that it was a political question because there were a lack of sufficiently manageable standards to figure out what torture was. And the Fourth Circuit reverses and says, listen, it's a hard question whether particular allegations of abuse do or do not constitute torture under U.S. and international human rights law. It is a messy question. It is not a standards-less question, right? And so it seems to me that part of what's going on in Judge Kavanaugh's concurrence in the en banc El Shifa decision and in the majority opinion by Chief Justice Roberts and Zivotofsky is this notion that one of the ways we create judicially manageable standards is by statute, right? That if Congress sets a floor, the courts can at least decide if the government has dipped below the floor, even if it's not sure how far above the floor they might be in other cases.
I think Judge Edwards foreshadowed that statutory issue a bit also.
Let me ask you this question, Harold. Is there any kind of potential challenge to executive action in the foreign affairs area that you think the political question helpfully would apply to, or would you just rely on other doctrines that limit things like no cause of action, no standing, those sorts of things, the usual bread and butter that the federal government uses to block plaintiffs all the time?
Well, a long time ago, 31 years ago, I wrote an article called Why the President Almost Always Wins in Foreign Affairs. And it's for the simple reason that in a foreign affairs action, you say it's not ripe, it's not ripe, it's not ripe. Then it's moot. And if it were not moot, equitable discretion means you can't grant the remedy.
Right.
And if you got to the merits, it's a political question. And then, by the way, if it's a legal question, we win on the merits. See Zivotofsky.
Right.
Now, the government can lose some of these arguments, namely the political question doctrine, and still win most of the cases. And I think that's exactly what would happen. I just have to mention and I know Judge Edwards remembers him very fondly, my late boss, Malcolm Wilkie, who is a very conservative judge, in an en banc case called Ramirez versus Weinberger, which was about whether the U.S. Defense Department could take over an American citizen's land in Honduras. There were people on that en banc court who were saying it was a political question, and Judge Wilkie for the en banc said, are you kidding me? These guys are taking military forces and seizing this guy's land, and that's a taking. And since when is that a political question? There are clearly judicial standards that can be applied. And the context, it's the difference between political cases. There are a lot of political cases and political questions, and there aren't that many political questions.
Political questions within the meaning of the doctrine we're talking about, right? Yeah.
One point I just make about that, too, is I think that acknowledgement of the takings cases and all is answered by the kind of current D.C. Circuit authority by pointing out, for example, in El Shifa, there were no constitutional claims. There wasn't a constitutional mandate.
In the D.C. Circuit. There was in the federal circuit.
Right, in the D.C. Circuit. There was no constitutional mandate for judicial review of that. And that, again, it played in both the no cause of action, but also this different view of the political question doctrine.
I really do think there's a meaningful distinction, and Beth, I know, is well, I may be oppositely biased from Beth in El Shifa, right? I mean, I think there's a meaningful difference between the claims that the plaintiffs brought here and the claims that they brought across town. Because the claims here were defamation, libel, very sort of common law-ish, right, tort claims, whereas the claim in the Federal Circuit was an unconstitutional taking. Now, folks might say, well, wait a second, non-citizens outside the United States, how can they invoke the Takings Clause? Well, there's actually a very old Court of Claims decision, which is the law of the Federal Circuit, that non-citizens overseas actually have Takings Clause rights. So I actually think it's not, I think, possible to fairly tie these cases together in a nice little package. I actually think there are real problems in at least some of the outliers.
I just want to say, to kind of bookend my first comment about the richness of the D.C. Circuit jurisprudence in this is not a criticism, but it really is at the other end of the spectrum for the Federal Circuit. Obviously, that is not the typical, although they did have the old Civil War cases about
Pacific
bridges.
Railroad.
Right, the railroads and all, really historical, interesting cases there. I do think there just isn't that kind of a development, and we don't get other opinions from them following up on that analysis.
I mean, I think a lot of this exchange, tees up the question that Judge Edwards posed toward the end about, as a practical matter or as a matter from the perspective of sort of constitutional values, what difference does it make if a court resolves a case on political question grounds versus no cause of action, or one of the other, you just win on the merits if you're the government? And, I think the answer to that, if you are a purist about the idea of the political give and take, is that it's not appropriate for courts to inject themselves because that constrains the give and take of the political process. But I think even more broadly, beyond just the political question context, that I think is an instinct that's passed by the wayside in a lot of different contexts. If you think about sort of old Commerce Clause kinds of decisions, like sort of the Garcia National League of Cities kind of idea that courts shouldn't be too aggressive about enforcing limits on the enumerated powers because there will just be this back and forth between the states and the federal government about the reach of Congress's authority, and that got kind of overtaken in the Morrison-Lopez line of cases. And I think there's a little bit of a similar thought in the political question cases, that it's not as inappropriate for the court to step in when it's simply a traditional Marbury, say what the law is kind of question.
Valuing a statute in particular.
But with regard, with regard to that though, then it seems like one of the answers to what's the difference is the next case. Right, because so Walter Nixon's case is a good example of this, right? In the Walter Nixon case, you have this division between the whole court is convinced that it's a political that Nixon loses, right? Chief Justice Rehnquist writes a majority opinion that says he loses because it is never justiciable for someone who is removed by the Senate after being impeached to try to collaterally attack the means by which he was removed from the Senate.
This was using a committee to try the impeachment,
right? And so Rehnquist says never reviewable, and Justice White says, well, I mean, nothing bad happened here, but you really want to say never, Chief? Right? And Justice Souter says, what if they tossed a coin? And so I guess my question is, right, under Chief Justice Rehnquist's logic, if in the next impeachment case the Senate really had flipped a coin, there would be no judicial review.
Right. I mean, I think that goes to Judge Williams' question about the consequences of the decision here will affect the back and forth of the political process in the future, which kind of like the AT&T case that this court had shortly before Goldwater, which really reads very much almost like a mediation of a labor dispute kind of thing.
Right.
We want the parties to go negotiate. They haven't settled yet. We're going to come in and give them some
make them work at it a little longer
guidance and
before we get involved.
But I guess there are better
congressional subpoena
doctrines.
cases I can think of that follow that.
But I guess I'll just say, I think there are better, like if the goal is to facilitate interbranch dialogue, then I think there are better and narrower doctrines for courts to use in the political question doctrine. And indeed, I think that's what Justice Powell was saying in Goldwater itself. I mean, Powell says we should, this isn't ripe yet, right? Because Congress hasn't really forced the issue. But I'm sorry, Harold.
Go ahead, Harold.
Well, I think we should hail both Judge Edwards and Judge Williams for their role on these political question cases. I think Judge Edwards has consistently taken a position that reminds me of Lou Hankins' position in his famous article in 1976, where he says, look, these things are justiciable, and I'm prepared to rule that the president has the power. In other words, the political question doctrine really defaults to the substance. Judge Williams has one of the greatest lines I've ever read in any opinion, which is in his Nixon case, which also held those non-justiciable. He says, I suppose there might be some example where the Senate might delegate its trial power to a bunch of school children, or like Caligula giving it to making his horse a senator, he could delegate it to an elephant in the National Zoo. And then he says, but I'm not sure at that point it would have sunk to a level where no court could have solved the problem. My own view, frankly, is something like that, where a delegation of the impeachment power was taken so far outside the legislative branch, might well be justiciable, whereas the Senate saying that it can be done by a committee as opposed to the whole Senate is not justiciable.
But this is an area where you support the non-justiciability doctrine on the impeachment case. Unlike sounds like in almost any foreign affairs context, you think it really doesn't have a role to play?
It's not in the impeachment context. It says that the Senate shall have the sole power to try.
Yeah.
And it's for the Senate. This is what Hamilton in Federalist 78 said, that in some areas, constitutional bodies are the judges of their own procedures. And that's one of the examples. Nixon is right there. The Senate determines who constitutes the Senate for purposes of trying an impeachment.
Although, at the risk of being annoying, more annoying.
Too late.
I know, right?
We love it.
Justice White, in Nixon, Justice White actually disagrees, right, with how Rehnquist reads the word soul, right? White says that the word soul is not at the exclusion of the judiciary, it's at the exclusion of the House, right? That because the only other place where that word appears in the Constitution is that the House has the sole power to impeach. And so the idea was to mandate the order of battle as between the House and the Senate, not to cut the courts out. But I mean, all this is just to say, I think we all share Harold's instinct, right, which is there was almost certainly nothing wrong with how the Senate removed Judge Nixon, and had they really delegated the power to a zoo animal or flipped a coin,
Right.
we all, I think, share the instinct that the courts would probably have found a way to say that's not kosher.
Well, so let me introduce into the conversation the gerrymandering context, because I think it's sort of illuminating. It seems very different in some ways from a lot of the other contexts. The gerrymandering cases that have been going on now since Davis versus Bandemer, and you can go back to before Baker if you want to talk about one person, one vote cases, are cases where there really isn't anything about textual commitment. It's all about the absence of manageable standards. And there have been 3 votes in Davis versus Bandemer, 4 in Veith, arguably 5 in Veith, to say there aren't manageable standards. And the issue arises from the fact that the court has this instinct that they're not going to try to eradicate partisanship from the redistricting process. They only want to try to police the boundary between really bad and sort of bad, and that creates a line drawing problem that hopefully in Gill versus Whitford we have solved, but we'll find out. Is this an area where you think that the doctrine of political questions, justiciability, has played a useful role, or is this just people using the doctrine conveniently to get to a result they want? What do people think about this?
I think it's what got us into the mess we're in. I think it's what got us into the mess we're in. I think
Well, that's true.
it's appropriate for courts at some point to say, this goes too far. And they don't have to be so specific about exactly what the standard is as to say that this is so far beyond the standard.
That's the position I took last October in front of the court. Don't ask me about lines yet. I'll worry about that in 10 years.
But there's an intelligent man on the street who we're worried about, Paul.
Yeah, right.
I'm sorry, Beth.
I was just going to say, though, I do think that part of the doctrine here in the D.C. Circuit and the foreign affairs and national security does also have to do with the comparable, view that there isn't a manageable standard. I think that case about the People's Mujahideen, it's about the designation of the foreign terrorist organizations, and it's a statute, and Congress laid out 3 different or 4 different steps about how the executive branch designates a foreign terrorist organization that involves various restrictions on what they can do and all. And the court here, I think, it said 2 were reviewable. The third was like, is it a terrorist organization? Is it something else? But whether it threatened national security, that was not reviewable. And I think that was because of an absence of standards.
Yeah, I guess I wonder, Paul, if there's an original sin contaminating the gerrymandering cases in the form of Luther versus Borden, right? So why, for example, is it the First Amendment or equal protection that's doing the work constitutionally when there's an express provision in the Constitution that guarantees Republican governments within states, right? That says republicanism, which I at least think can neutrally be interpreted to mean representative government within states. And so, I think I'll ask you a question, right? If you could have litigated Gill as a guarantee clause case, would you have liked to?
I actually don't think that which clause you pick makes any difference. The issue is whether or not there's been excessive viewpoint discrimination in deciding how to draw the lines to favor one party over the other. And you would have the same problem, I think, if you were saying that this map is so biased that it so predetermines who's going to win that it's not Republican form of government. I don't see how that. You still have the issue of how far is too far. If you're not going to try to set the standard that no amount of partisan consideration is permissible. It was something that the court's never been willing to do because they think you're telling people to draw these lines for themselves. They're political actors. Telling them not to think about politics is crazy, right?
But contrast that, right, with Reynolds and with Westbury. I mean, right, so you have these remarkable cases in the 1960s where the court starts talking about the size of districts and how the states have to have pretty compelling justifications to have districts that are of meaningfully different sizes by statistical means, right? So, and the court basically all but ends up drawing an arbitrary line somewhere around, 0.something% for the numerical variance
for congressional districts.
For congressional districts. Yeah. It's totally arbitrary, right? It is a pure act of just sort of picking a rule to have a rule. And I guess I don't see why that exercise of judicial power is somehow meaningfully more or less appropriate than doing the same thing in the context of partisan gerrymandering.
I'm totally agreeing with you. That's my position. But and they set a 10% safe harbor for the state legislative districts, which is completely out of thin air. And eventually, if we're right that they're going to buy the measures we've given them, the efficiency gap or whatever it is, they can pick a number.
But I guess so. If I can quibble slightly, I guess Beth, I teach the political question doctrine, perhaps incorrectly, a little bit differently than the way you just suggested it, right? Which is, I actually see the foreign relations cases, even the ones that claim to be going down the lack of standards prong as opposed to the textual commitment prong, as really being about a different set of concerns than the gerrymandering cases, right? Because in one, the former class is about horizontal separation of powers. Right, it's about sort of the court stepping on the coordinate branches of the federal government, right? Whereas the gerrymandering cases are about federalism.
I actually agree with you, and I think even to put a further nuance in it, when you talk about in the foreign affairs, I think it's another one of the factors in Baker that isn't really articulate anymore. It's that embarrassment factor that kind of is the way it's phrased, but it's really, and it goes to part of the argument I think that Harold was making and about who speaks in foreign affairs and that role, but I do think that this idea of embarrassment really goes to this horizontal power, and it becomes much more complicated when it is speaking outside of the United States.
And I guess to me at least, the complexity of speaking outside the United States is at least to some degree a function of whether Congress is part of the speaking. And so we're back to the statutes, right? And back to why I think where there's a statute, it's a different issue. But I also think that it puts, at least to my personal idiosyncrasies, the foreign relations line of cases on less troubling footing to me than the federalism cases, right?
Less troubling than what?
Less troubling, right, to me, than the federalism cases. Because in that context, right, the separation of powers argument is that the courts are intruding upon the sphere of the other branches. Whereas in the gerrymandering context, it's the court trying to enforce the Constitution against states.
Right.
Can I ask a historical question? We had heard reference in the argument to the Vietnam line of cases, where I gather there was a whole series of decisions by lower courts throwing out challenges to the war from various plaintiffs' point of view. What was how did the issue play out in that context? I guess it's a standard sort of foreign affairs thing. Was it textually committed? Was it absence of standards? Or they just said, I'm not getting into this, you go home, right?
Yeah, I read those cases as being primarily about a lack of judicially manageable standards. There are...
Seems wrong, though, somehow.
Well, but I think the way that some of the claims were presented were... The claim would come in a form like this, that the president is waging war. Congress has, though perhaps not through a declaration, at least through other actions, been involved and given various forms of assent.
Right.
But,
Tonkin Gulf resolution, all that stuff.
Right, exactly. But would Congress, when it did that, have anticipated that the president would begin bombing Cambodia or would mine the harbors in North Vietnam? And so the question was presented to the courts as, this is an escalation unilaterally beyond anything that Congress's assent would have licensed. A similar kind of assertion was made in reference to, I forget what there was one statute at the time that expressed sort of the sense of Congress that we really ought to try to wrap this up, and all of our efforts from now on should be toward bringing an end to the war.
Right, yeah.
And the bracket a major question whether a statute like that would be constitutional and binding, and but assuming that it is, how do you judge whether the president's decision to escalate will or will not bring about an end to the war?
surge,
How
right?
will you judge whether the decision to escalate is or isn't an unforeseeable change in the conduct of the war? And so with respect to those particular kinds of claims that were being raised, I think the cases generally take the view that how is a court to even have the evidence that one would need? How does it have competence to evaluate that evidence? And what business is it of ours to decide whether this is the best decision about how to conduct the war so as to bring an end to it?
Helpful. Harold, what's your perspective on those cases?
Well, so there's the two kinds of cases. There are the pre-war powers resolution cases and the post-war powers resolution cases. The Holtzman versus Schlesinger was the key case because that was the one where Justice Douglas came down from Yakima, Washington, and stayed the bombing. But then by the time he got back to Washington, the court sitting as a court, and an opinion by Justice Marshall, had vacated his ruling, and that was pretty much it in terms of whether they would actually rule on the merits. But once they passed the War Powers Resolution, and John Hart Ely writes very powerfully about this in his book, War and Responsibility, there was a lot of discussion about how justiciable it ought to be because it's a statutory case, and you have, Japan Whaling Association, and now Zivotofsky, which essentially say that statutory cases, particularly if the claim is that the statute violates or encroaches on constitutional authority, is at least justiciable. But as a result, in this court, Lowry versus Reagan and other kinds of cases have held these war powers resolution cases to be non-justiciable, but without a very good rationale.
I think there were pretty obvious political reasons why the court didn't want to step in one way or the other on the Vietnam question, for better or for worse. If I could go fast forward, though, I think we'll put two cases side by side, right? So there's a case right now pending in the DC Circuit called Smith versus Obama, and there's a case pending in the DC District Court called Doe versus Mattis. And both have at their core the question of whether Congress in the 2001 authorization for the use of military force authorized the use of military force against ISIS. Right, a fairly important question to contemporary United States counterterrorism policy. In the Smith case, the district court dismissed the lawsuit on two independent grounds. One, that the plaintiff, who's a service member who is challenging his potential deployment, lacked standing, and the other, that in any event it was a non-justiciable political question. In Doe versus Mattis, because it's a habeas case, right, of an individual who's in U.S. custody in Iraq, no one is arguing that it's a non-justiciable political question, even though it is the exact same legal question, right? And so I guess I just, it seems to me that we can talk about who's the right plaintiff and what is the right, ripe and non-moot dispute. But if we're going to have the view that those two cases raising the exact same question are at complete loggerheads when it comes to the political question doctrine, I think that tells you a lot about the political question doctrine, and not much of it is good.
Good. We have about 1 minute left. Does anybody have final comments or thoughts to sort of tie all this together? Yes, I knew you would, Harold.
I think Justice Blackmun had it right in Goldwater versus Carter, which is it should have been argued to the court. They had enough time. They disposed of it summarily because they wanted to get the opinion down before January 1st, 1979. I forget when it issues, around December 12th. They could have heard it on the merits, and we would have had much better decision-making. As a result, it was a summary disposition. The DC Circuit had a very detailed en banc, which in fact, none of the judges went for the political question.
Right, 0.
So I think it was, on summary dispositions, political question at the Supreme Court can be a cop-out. But now that they've got Zivotofsky, it's a lot harder for them to do that. So I think the correct disposition there, or if we have a future case now involving a attempted withdrawal from a treaty, is set it for argument and have the full plenary disposition.
Okay, well, let me ask everyone to thank our wonderful panel and our panel of judges as well.